there is a balance, a proper balance between what the federal government's responsible for and what the state government's responsible for. Now, we have a lot of fighting right now between our federal and state governments because I think there's a lot of fighting in our society about policies. For example, take drug legalization, which you talked about. Marijuana and other drugs are prohibited under federal law. This doesn't mean that states have to legalize them or not. But what the federal government doesn't allow, what the Constitution doesn't allow, and as you mentioned, what McCullough doesn't allow, is for states to try to prevent the federal government from performing its constitutional functions.
Welcome to another episode of Counterculture, the show that stands at the intersection of reason and faith in the battle against sentimentality. Is America descending into a Hobbesian state of nature, which is to say a culture where political might makes right is replacing equal justice before and equal protection under the law? The rise in violent crime, the historic levels of illegal immigration, the legalization of drugs at the local level that are prohibited at the federal level. Are these simply fleeting personnel problems and leadership issues, or do they represent the beginning of a very real structural breakdown of the republic? Now, layer in the lawfare at the federal level, as represented most graphically by the Trump indictments and the Biden family corruption, and consider the level of the judicial branch's decay. What happens when officers of the court become the Praetorian Guard of a political ruling class? What happens when the law is used as a tool of vengeance? To help us explore these and other questions, we're pleased to be joined by Cal Berkeley law professor John Yoo. Professor Yoo earned his law degree at Yale, and he clerked for another Yale law grad named Justice Clarence Thomas. He also served as a former Deputy Assistant Attorney General in the Office of Legal Counsel at DOJ under President George W. Bush. Professor Yoo, welcome. Thanks for joining us. Appreciate it.
Good to be with you.
Well, I was thinking about this recently, and I wanted to apply what I learned in law school since I never practiced law. And I was thinking about the McCullough v. Maryland decision of 1819, which established that federal law was supreme over state law. And if we're not in a period of neo-nullification, which would be a breakdown in the rule of law, and I mentioned at the outset, prosecutors at the local level who won't enforce criminal code, our refusal to enforce immigration law, and at the state and local level to respect federal immigration law. And of course, as was mentioned, drug legalization at the local level or the state level, state and local level, where the same drugs are prohibited at the federal level. How serious are these conflicts in the rule of law in the United States, in your view?
To start with, we should remember that the founders did want to create a decentralized system of government because they were afraid of concentrated power. And so, as you mentioned in McCullough, in many of your examples, there is a balance, a proper balance between what the federal government's responsible for and what the state government's responsible for. Now, we have a lot of fighting right now between our federal and state governments because I think there's a lot of fighting in our society about policies. For example, take drug legalization, which you talked about. Marijuana and other drugs are prohibited under federal law. This doesn't mean that states have to legalize them or not. But what the federal government doesn't allow, what the Constitution doesn't allow, and as you mentioned, what McCullough doesn't allow, is for states to try to prevent the federal government from performing its constitutional functions. We could argue whether the federal government ever should have gotten into the business of legalizing drugs or not, but once they've decided, once there's constitutional authority, states should not be trying to frustrate the objectives of the federal government. On the other hand, the federal government also shouldn't be using its powers to try to interfere with what states can legitimately control or not. So you also mentioned, Dan, immigration. I think this is a really hard issue because obviously the federal government under the Biden administration is not fully enforcing the immigration laws. They are allowing millions of people across the border and just releasing them into the country when federal law requires the detention and ultimately deportation of people who are here illegally. And so states have some authority, I think, to try to control crime, to try to control illegality that occurs when people are crossing the border into their states. And if the federal government comes into court and tries to stop states like Arizona or Texas or Florida, for example, from trying to control crime in their borders, I think that's when the federal government has gone too far.
And what about when the states have gone too far? I mean, not this administration, but say the previous administration, where there was a serious effort to enforce immigration law, and you have jurisdictions at the state and local level that were, well, to use your words, trying to frustrate that law enforcement by declaring themselves sanctuaries, by not cooperating with federal law enforcement. Is that an instance where states go too far?
I think that's a good point, Dan. I think states aren't really supposed to have an immigration policy. That's up to the federal government. But I do think states go too far if they try to prevent the federal government from doing its job. So here's a good example. The number one priority I think we can all agree on for federal immigration enforcement is to catch people who have committed crimes in the United States and remove them from the country as fast as we can. But the arrest and trial of most felons in the country, like 99% of them, is up to state and local governments. State and local governments are the ones in charge of crime. And so what bothers me about states like California and states like New York, what they were doing is they would arrest people for committing sometimes very violent crimes, and then they would just release them from prison, even if they were illegal aliens, and not tell the federal government that they were releasing them, where they were releasing them, why they were releasing them, which effectively was right taking people who should be removed from the country who committed violent crimes and just letting them go back into the population to commit more crimes.
So generally speaking, I mean, uh, do you see the breakdown of the law of the rule of law, I should say, as largely a political problem, or is it a structural one? You know, I mean, is it a fleeting political one, sort of as I queried at the outset, where if you had some better prosecutors in big cities and you stopped insinuating yourselves in the enforcement of federal immigration law, then I think, you know, you can argue about the prosecutorial discretion in particular cases involving repeat violent offenders, but generally speaking, we're not fraying at the edges. Or is it more serious than that?
Dan, I think you know the answer to that question better than I do. My hope is that this is a passing political phase we're going to, but that the foundations of our constitutional republic are not under threat. So just a small thing is you're starting to see very democratic liberal mayors, like the mayor of New York City, like the mayor of Chicago, becoming upset now about these sanctuary policies, becoming upset about the lack of enforcement of immigration law at the border because they realize that they've gone too far. And now they're, as you can see, they're asking the federal government to take a firmer hand in the way immigration enforcement is pursued. So my hope is that people have seen the terrible consequences that can arise when there's disrespect for the rule of law, when people carry their political fights too far into trying to use the legal system, trying to attack constitutional norms, and that they'll pull back now. And maybe you're seeing this happen at least a little bit with these big city Democratic mayors who now realize an open borders policy is a terrible idea.
All right, let's talk at the federal level. The marquee stories, the Trump indictments, and the investigations, to the extent that they're real investigations into Hunter Biden and the Biden family. Start with the Trump trials. I mean, we haven't spoken about this, so just your general overview. I know each indictment and each jurisdiction is different. Your general overview of the nature of these indictments.
So first, I think it actually goes to the point you were raising before about politics being taken too far and undermining the rule of law. One thing I don't think is healthy for the rule of law, one thing I don't think is good for our countries to have state prosecutors essentially trying to litigate what is really a federal issue here, which is what happened on January 6th. What did President Trump do or not do? I don't think, and whether President Trump should be on the ballot for 2024. So you have these prosecutions, right? One brought in New York City, another brought in Atlanta by state elected DAs who are essentially, I think, trying to prosecute Donald Trump either for what happened on January 6th or to keep him off the ballot in 2024. I think this is a dangerous idea. First, because I don't think the states should be involved with those questions. I think whether there's a prosecution of Donald Trump or not for January 6th, that should be up to the federal government. That should be up to federal prosecutors. That's why you see, I think, these state DAs stretching the law, conjuring up new theories of prosecution, using laws that have never been used this way ever before to prosecute a former president, which has never happened before. And think about what that could spark, because since it attacks the rule of law, once that happens, then what's to stop red state DAs from prosecuting the Biden family, from prosecuting future Democratic nominees for president, prosecuting past Democratic presidents? Once you open up this kind of this can of worms, you're going to allow retaliation that will occur. And that, I think, really breaks with a norm we've had since the beginning of the country. Basically, you leave past presidents alone. If there's something extremely serious, you could use impeachment, you could use federal prosecution, but we don't want 50 states prosecuting former presidents.
Well, I mean, in the case of Atlanta and New York, with the DAs there at the local level, even if they were to secure convictions, they can't keep Trump off the ballot. That would still be I mean, if New York or Georgia, there was one of these 14th Amendment Section 3 cases like we see in Minnesota and elsewhere, Colorado. I mean, they could pursue that, but Trump can be convicted of crimes and still be on the ballot. He can be convicted of crimes and still run for president. So what you're saying is that they're essentially doing this for political reasons to debilitate his candidacy. And this is the way they do it, by stretching the RICO statute in Atlanta, by stretching the Business Records Act in Manhattan.
Exactly. They're not trying to formally keep him off the ballot, although other people are trying to do that.
Yes, right.
I think under misreading of the 14th Amendment. But what they're trying to, exactly right, they're trying to get a conviction because they believe that if you can convict him, that enough people will turn their backs on Trump. That we've, that there's no way people would ever elect someone who's actually been convicted of felony. Although I would add that it seems to me there's no way that President Trump could get a fair trial and have the right to appeal in time for the November elections. But that's not going to stop the DAs in New York and Atlanta anyway. But as you said, there's this whole nother effort, again, designed to keep President Trump off the ballot in 2024, making the claim in state courts that President Trump was involved with the insurrection on January 6th, and so therefore the Constitution prohibits him from appearing on the ballot again. Again, I think this is a stretch of the law, because which I think undermines the rule of law, because the left wants to keep Trump off the ballot. But I think if you look at the text of the 14th Amendment, it only applies to what are called officers of the United States who are cabinet members and below. It does not mention the president. I don't think former presidents are covered by the 14th Amendment disqualification of people who are involved in insurrections. I think what the founders thought here and again is that the voters should decide. Why do we need prosecutors and state judges to prevent the American people from making a choice about who they want as president?
So let's go to the other two cases where you do have federal prosecutors bringing the charges, the classified documents case and the Jan 6 case. What's your assessment of the quality and propriety of those cases?
So I think that the documents case is actually the most serious one that's being brought by President Trump against President Trump But again, that one has nothing to do with President Trump's candidacy. It has nothing to do with January 6th. I don't think it's important enough. And this is for prosecutors to bring. I think this is a case of the judgment of prosecutors about whether to bring a case at all using their discretion. And I think when you're dealing with former presidents, especially someone who's running for office, and these prosecutors work for the executive branch being headed by Joe Biden, who was President Trump's opponent in 2020 and is likely to be his opponent again in 2024, I don't think that's a good case. The only case I think that is a viable, important case would be the one connected to January 6th. I think if people on the left really think that President Trump was involved with the attack on the Capitol and that the attack on the Capitol rose to the level of insurrection, then they should bring those charges and try to prove them in court. The problem with the January 6th charges is that they don't charge President Trump for insurrection. They
Right.
don't charge him they charge him with things like interfering the process of Congress, which is an obstruction charge, which is usually brought against people who destroy documents. They charge him with trying to defraud the United States, which is usually brought against government contractors and sort of Medicare and Medicaid providers who overbill the government. These are not the serious charges about insurrection that I think you really should bring if you want to convict a former president for January 6th.
On the classified documents case, you were at Department of Justice. How do we have such profile on the case for the former president and no profile, I mean, almost zero profile on the case involving the incumbent president and all the documents that were found at University of Pennsylvania and in his Corvette and in his home and so on and so forth? You had a special counsel appointed, a guy named Robert Hur. People have probably forgotten he even exists for understandable reasons. And there's just nothing coming from him. I mean, I don't expect the press to be looking for ways to report on this, but you would expect something from this special prosecutor over the course of the many months now that he's allegedly been on the job. Does that strike you as bizarre that he's just sort of disappeared?
As a former Justice Department attorney, I think one of the most important things that the department should do is build public respect for the law to make sure the public believes prosecutors are acting with integrity and that they're treating, the most important thing is they're treating like cases alike. They're treating people in the same situation in the same way. And I think your concerns, Dan, are important because choosing to prosecute Trump and not choosing to prosecute past presidents who've also held classified documents looks like selective prosecution. It looks like the Biden administration is trying to go after its political opponents. Even if you were to give the special counsel Jack Smith a very generous presumption, maybe he thinks he's doing the right thing. Maybe he doesn't care about the election. Maybe he doesn't care Trump's Republican Democrat. But the most important thing is that the public have confidence that the Department of Justice is being fair across cases. And if they're singling out Trump and they're not bringing the same cases against other people like Biden who've also violated classified information procedures, then they're going to undermine the ability of our legal system to work in the future because people are not going to cooperate. People are not going to help. The prosecutors and FBI agents really depend on the cooperation of the public, which depends ultimately that the public believes justice is being done fairly. And I worry that singling out Trump for these classified documents, alleged violations, but not prosecuting others is going to create this kind of cynicism in the public, and that will undermine the rule of law going forward.
What about David Weiss's performance, the special counsel, U.S. Attorney for Delaware, that's supposedly investigating Hunter Biden, who's brought the gun charge against him? He gave this bizarre testimony that was released by House Judiciary Committee. I think it was House Judiciary, where he said that he sought approval for charges He went to U.S. attorneys in Washington and in California and wanted them to partner to bring charges against Hunter Biden. They declined, but he didn't call that a denial. He said because he later, weeks later, got the green light to go ahead with the investigation and the potential prosecution, that the previous denial wasn't a denial. And this is my read is, in addition to parsing words, is so he doesn't run afoul of Merrick Garland, who said that David Weiss had complete authority to bring any charges he want, when that clearly wasn't true. So rather than saying Merrick Garland was wrong, this occurred to me, I got denied. So he's saying I wasn't denied, even though I had no way of knowing that weeks later I would get green lighted when I was denied, but that's not a denial. I mean, I'm confusing myself even trying to explain it.
Look, what you've explained clearly is that David Weiss should not be the special counsel.
Yeah,
This is
well,
right. This is the real problem with this is the reason you bring in a special counsel is because you're worried about a conflict of interest, because the prosecution is bringing an investigation against someone related to the president. And it's undeniable. You can see just in the way you describe it, Dan, that Weiss was slow walking this investigation. He was reluctant to really pursue it because he's in Delaware and the Biden family's from Delaware and the president and his son are involved. And so the first thing you should have done if you really wanted to appoint a real special counsel is bring someone from the outside. The last thing you would do is say, oh, the special counsel is going to be the prosecutor that we think is subject to the conflict of interest and has been slow walking this whole thing and was probably going to give Hunter Biden a sweetheart plea deal. That really actually brings so some people say, oh, well, this just involves things that were going on before Biden was president, when he was a private citizen, and Hunter Biden. But this appointment of the special counsel and the way it's done, the slow walking of the Justice Department here through David Weiss actually brings this kind of scandal into Biden's actions as president. It's not just a matter of what Biden did in between the Obama administration and his election. This is now raising questions about whether there's been an abuse of power by trying to delay or slow down the investigation while Biden's president.
well, it's also too something else about Weiss. So he's lying, and that's not the only lie he told in testimony to the House. And this goes back to Comey too. And people watch this and they know these guys are lying. An inspector general says they are lying, or a judge in the Weiss case, which I'll get to, says they're lying, and there's no consequence for it. But they ensnare other people in process crimes for lying under oath to an FBI agent or a federal official, and put these people through the ringer. That's a form of lawfare too. But Weiss said that his intention in testimony to the House Republican majority committees, that he always intended to continue the investigation, even with that plea deal that was rejected by a federal judge. But the judge in the case concluded that it was clear they had a rider that all of this was going to go away, that it was a universal plea deal. So he's saying that he intended to go when his actions previously when his actions previously said he wasn't going on, that it was going away. And there's no consequences for David Weiss other than, my ridicule, and that's not much.
Well, the consequence is going to be, I hope, that this is going to be investigated by Congress, that it will actually end up being a serious charge or accusation against the Attorney General and the President, because, again, they should not be appointing the U.S. Attorney in Delaware, who created all these problems, to be the special counsel. They've only compounded the conflicts of interest that already existed and that we've already seen at work, as you said, by this sweetheart plea deal, by keeping Weiss in charge of the continuing investigation. The sad thing from the Justice Department perspective is that they didn't discover a lot of the things that we know about now, that these have only come to light because of the investigation by the House Oversight Committees, as you pointed out, Dan. That's why we know about all the things that have been said by Hunter Biden's business associates. This is where we're learning about what's going on at the Justice Department. That is embarrassing. That's showing that the Attorney General and ultimately President Biden are not fulfilling their core constitutional function, which is to execute the law, that they're playing political games with the investigation into Hunter because obviously they're afraid that this is going to lead to Joe Biden ultimately.
How much has the Department of Justice, and I include the FBI in that, how much have they fallen in your estimation as institutions over the last several years?
As you said, Dan, this started with with the Russia hoax. I mean, you saw, as you mentioned, the Inspector General of the Justice Department found that very high level FBI officials lied to Congress, lied to the Inspector General himself. And ever since, you saw an FBI director essentially trying to entrap the sitting president into some kind of obstruction of justice charge, and I'm referring to Jim Comey and his efforts to further pursue the Russia hoax investigation. I think it's been downhill. And then I think, as you say, all these questions about the Hunter Biden investigations, all these questions about the way that the Justice Department has been, I think, prosecuting selectively Donald Trump. This is undermining people's faith in the rule of law. Personally, I think if people don't like Donald Trump, then they should just express themselves at the ballot box. If Trump makes the ballot in November 2024, then let the people decide whether they think President Trump is responsible or not for what happened in January 6th. But what I don't think is that we should be stretching the law, that we should be advancing unprecedented theories and interpretations of the criminal law to try to knock Donald Trump off the ballot or to try to damage him in some way to prevent people from having that choice in 2024. I think the founders really thought that the political system and elections would be the way we resolve these fights, that we resolve these disputes. Let Trump and Biden both be on the ballot. And then people can decide, is President Biden to be trusted with heading ultimately law enforcement and justice and the Justice Department? Was President Trump in some way responsible for what happened in January 6th? The people can make up their own minds.
You know, it's rather ironic, and ironies abound these days, but the one hand, these prosecutors are advancing these novel, unprecedented theories that we've been discussing. On the other hand, they're prosecuting Trump and others, including John Eastman, former law professor at Chapman University, for advancing novel legal theories about what powers a president does or doesn't have. And I know you got involved in the John Eastman case in terms of, I think it was a testimony at a disbarment hearing.
Yes.
And so, so just speak to your involvement there, because I was always struck by, I didn't find Eastman's argument persuasive, but and there were some filings in court challenging the election results after 2020 that I didn't think, Sidney Powell and Giuliani, I didn't think they put together a very good case publicly or in terms of complaint forms submitted by a court. But that's not criminal. That's not criminal to put together a complaint that has some holes in it, or to advance a legal theory that isn't supported by the evidence or isn't persuasive to the court. Now this is criminal.
Dan, I think actually we agree on all fours about what happened here. I didn't think that the Trump campaign and the Trump lawyers proved that there had been sufficient fraud to change the election results. So I disagreed with John Eastman on the facts. But I actually don't disagree with him that much on the law, in the sense that if there were a real dispute coming out of a state, like you had differences between the governor and the state legislature, or the election was still tied up in litigation by the time it was time to count. And this has happened before. This happened most famously in the election of 1876. But if that happened, I thought, it's a hard question, but I thought certainly a reasonable position that the vice president, rather than Congress, would resolve that dispute. So that's what I did when John Eastman is currently under proceedings in California to strip him of his bar license and to prevent him from practicing law ever again. And my testimony was, as you said, when did it become illegal? When did it become a subject for someone to be investigated and punished when they give their best view on a legal question and they're giving advice to their clients? And a client here happened to be Donald Trump. But the last thing we want to do, and this is not like a question of what is the definition of murder? This is a genuinely open question. There have been no judicial decisions. This provision about who counts disputed electoral votes has never been interpreted by any court. And so why do we want to suppress different views? Why do we want to pretend there's an obvious right answer to that question when there's obviously a diversity of different answers, and that you could, right, give the president or give the candidate, here's different possibilities and here's the legal authority for each one, and to admit this is totally new, unprecedented question. I think, again, as you're saying, Dan, the people opposed to Donald Trump want to stop him so badly. They're trying to use the legal system to punish anybody who ever helped him or gave him advice. And I'm worried that that is twisting our legal system and undermining the rule of law, which is one of the great successes of our American constitutional system.
You know, I mean, the other thing with the Eastman case, and any case, is even if it's so-called settled law. I mean, say somebody wanted to challenge the holding in Marbury versus Madison, judicial review, and somebody came up with a novel legal theory to say why judicial review shouldn't apply. Should they go to prison? I mean, is that seditious to come up with a novel legal theory about a case that's been settled law for 220 years?
So this is what's going on with Eastman. I think Giuliani, other lawyers, even though, as I said, I disagreed with their ultimate view on what happened in the election, is so their efforts to prevent them from ever practicing law again, which is basically taking away their ability to make a living. And then Georgia, the Georgia case is actually trying to throw them behind bars. The Georgia case is saying your views, this is the accusation that Fani Willis, the DA, is essentially making, is John Eastman, Rudy Giuliani, your views are so outside the realm of possibility that you were just really covering up for a criminal act. It's a kind of claim you would bring against a mafia lawyer, for example. But I just don't think, as you said, that's just not the case here. Anybody can see that this question is not one that, you could just look up in a book and say, oh, here's the exact right answer that everybody knows. This is a question with the highest stakes, the question of basic constitutional interpretation, which no one had done before. There's no court decisions. There's no Supreme Court case about any of these issues. Never reached the Supreme Court. So lawyers have to have even more flexibility, I think, or room to maneuver when there's no opinions out there from any kind of authority about what these provisions of the Constitution mean.
And what is the argument? I'm just curious, since you've been so involved in this. So what is the argument in response to what you've just offered that's being made by those seeking Eastman's disbarment?
Well, this is basically the same argument there, and I think they're making the same argument in the criminal case in Georgia, which is that, it's obvious that if there's a disputed electoral vote, that Congress decides, not the vice president. And so you, Eastman, Giuliani, Trump, ultimately, you were just making up some kind of legal interpretation, which everybody knows is wrong, to claim that you weren't really committing a crime. That's essentially their argument. I have actually written a very long scholarly article about this question, about is it the vice president who picks the correct electoral vote, or is it Congress? And it's my view that the Constitution structure and the founders' understanding would have rather had the vice president than Congress, because the founders did not want Congress to pick the president. That's one thing they were deathly afraid of.
You better stay out of Atlanta with those dangerous views.
There are many reasons to stay out of Atlanta.
I'm just warning you. It could get a little dicey. In the Georgia case, speaking of Atlanta, I want to get your take on this too, just your read on it as a practitioner. The pleading out that's going on with some of Trump's lawyers, and the idea that, well, they're closing in on him because they're going up the food chain and they're getting all these lawyers. But I mean, doesn't Trump have the eponymous Trump card here? Wait a second. My lawyers are pleading out. I relied on my lawyer's counsel when it came to these legal representations that were made in court and the arguments as to the theory of what happened in the election and why this should be recounted and so forth. And so I'm not a lawyer. So how does having his lawyer, having Sidney Powell turn on him and testify against him, doesn't he have the sort of walk away argument? Say, look, we had conversations. I relied on counsel, and they made the filings they made. They made the representations they made. They made the arguments they made. We didn't win the day, and that's that.
I think Trump has two arguments here. One is, as you described, I'm the client. I just relied on the advice of my attorneys. How am I supposed to know whether the attorneys are giving me good advice or bad advice? I'm not the lawyer, so I relied on them. Rudy Giuliani's former mayor in New York City, former U.S. attorney in New York, he has high credentials. John Eastman's constitutional law professor, clerked at the Supreme Court. Why shouldn't I rely on them? That's one argument. So that's why they're trying to say, the prosecution is trying to say, oh, that's not even, the legal advice was so bad, nobody would have thought it was true. But I actually think President Trump has a deeper, more important argument. I expect it'll be made at some point, which is the reason that you see prosecutors doing this is they're applying the basic playbook that we use against drug cartels and organized crime, where you say, oh, the whole enterprise that you're engaged in is a criminal enterprise, like the mafia. And so then that's what you do. You charge everybody for being a part of it, and then you try to pick off the lower level people first, turn them, get them to testify against higher up people. The problem here is that what Fani Willis is charged, this is the DA in Georgia, what she's charging as a criminal conspiracy is a re-election campaign. She's basically saying the 2020 Donald Trump presidential campaign itself was a criminal enterprise. I think that is a fundamental error. And so therefore, all of these tactics they're using could ultimately be held to be illegal, because you can't charge a presidential campaign, which is the very core of free speech, of political activity protected by the Constitution. How can you charge an entire political campaign as being a criminal enterprise? I think that's the basic mistake, and that's why you're seeing all these problems with it that you're raising.
Do you have these discussions with students at Berkeley Law School? I mean, what's the environment like for you at Berkeley? And I say that, I mean, against the backdrop of obviously what's happening on campuses after the Hamas terrorist attack, but even before that, the incident at Stanford Law with how boorishly a federal judge was treated by law students there. So this is Stanford Law. It's supposed to be one of the elite law schools. And we've seen so many instances. And I just wonder what your experience has been, what you're seeing, and what you're thinking about from the time when you were a law student to the time that you spent as a law professor.
So first, Dan, let me say I'm shocked and disgusted at the response I've seen to the Hamas attacks on Israel. And then I think Israel's right to defend itself. I'm not surprised that there are people in the country, some small number, who are anti-Semitic, but I have been shocked at seeing the concentration of anti-Semitism at our nation's elite campuses amongst faculty, administrators, and students. I just have been utterly disgusted by it, and I condemn it. Now, when it comes to what's it like on campus, I think that I used to say, Berkeley, lived up to its reputation. It's a very liberal university. What I've seen now, not liberal, progressive. It's a very progressive university. And I think you see these people sort of seduced by this sort of anti-Israeli views because I think there's a lot of sympathy for Marxist views in our top universities, and Marxist views treat Israelis as some kind of colonizers and occupiers against the poor Palestinians. I think that was common at Berkeley and has been for a long time, since the 60s. What I see now is that the other top universities have become like Berkeley. I don't actually think Berkeley is actually any different than what I see now going on at other campuses. Now, yeah, I do talk about some of these issues. I teach a class on the presidency every now and then. I've actually slated to teach it this spring. So, of course, we're going to go into all these issues and we'll see what the students think. But what I always tell them, and I last taught this when the class when we changed from the Obama to the Trump presidency, is don't forget that all the things that students say and do with regard to one president, would you feel comfortable applying that to a president from your own party? Would you be comfortable if the Justice Department were going to go after Joe Biden or Barack Obama in the same way that it's going after Donald Trump? Would you like to have elected prosecutors in Florida and Texas prosecuting former Democratic presidents? That's the best I can do in the classroom, is to say you have to think about how this applies to people you don't like.
Well, I just ask because, I mean, we're talking about the rule of law in our federalist system, and, in life and death cases, in cases that have great impact on the protection of constitutional rights and all these principles that provide the foundation for free society. And so, it's not just what's happening on college campuses generally, it's specifically what's happening at law schools because, again, we've had a couple of generations now, a few generations, and we've got another generation of lawyers that are incubating at places like Berkeley and those other elite schools that you just mentioned. And, that will have an impact on the quality of equal justice before and equal protection under the law going forward, too. So we might want to think about that when we see, like I said, the example I gave of how a federal judge is treated on the campus of Stanford.
I agree. I think that the more you see this kind of outrageous conduct tolerated by the students, the more you hear examples of teachers really bringing their ideological prejudices into the classroom, then that is going to undermine our trust that those institutions are actually producing good practicing lawyers, or from the undergraduate programs, good citizens who are going to make good employees. Look, if you were hiring a lawyer and I was hiring a lawyer, you don't want a lawyer who's going to say, okay, I'll take your case, but only if I can inject my own ideological views into what I'm going to do. And so if you see students coming from places and that's what they're doing, they're shutting down the right to free speech, they're harassing federal judges. These are not people you want to hire, and you don't want to hire the law firms that hire them. I think that's how we have to correct, is that adults in the marketplace, adults in companies, law firms, and so on, have to decide that these are not the kind of people that we want representing us, that we want working in our firms.
University of California, Berkeley professor John Yoo. Professor Yoo, thanks as always. Always great to talk to you. Really appreciate your time and your legal insights, of course. Thanks again.
It is great to be back with you, and happy to return anytime.
Please like this video and subscribe to this channel if you haven't already. And please leave a comment in the comment section. We'd love to hear your thoughts.